Hi, I'm Patricia Fonte and I'm an estate planning attorney. There are 5 things that I would like family law attorneys to know about a prenup's impact on inheritance in California. Today we're going to talk about a common misconception that a prenup controls the flow of assets at death. It doesn't. In California, a prenup can tell you who's going to get what in a divorce, but the probate code controls what's going to happen at death, absent estate planning. When these 2 things are not coordinated, unintentional disinheritance happens. If you're a family lawyer, financial advisor, insurance professional, or someone with a prenup, all of this really matters, and I hope that you're going to find this video useful. Number 1, a prenup is not a testamentary document. So a prenup is a contract, and it defines property rights between the spouses, and it's primarily for divorce. You're preserving your right as to who gets what when it comes to divorce. You're opting out of California's definition of community and separate property, and you're making up your own rules. A prenup is not a will. It's not a trust. It's not a testamentary instrument. So even if it mentions death, it might confirm ownership. It might include some waivers that say, even though under California law, I'm entitled to receive my spouse's community property, I'm going to waive that right. But it doesn't direct distribution. It doesn't say who's actually going to inherit. So if a person who is signed a prenup or a person with separate property dies without a will or a trust, the laws of intestacy control. So number 2, what happens to separate property under California law? This is where most of the surprises occur. So in California, community property, 100% to the spouse. Separate property, it depends on who survives. Separate property passes if the deceased spouse had a child, half to that child, half to the surviving spouse. They had more than one child, 1/3 to the surviving spouse, the remainder to the children. What if they didn't have children? The surviving spouse still isn't inheriting all of it because it might be that half goes to this deceased spouse's parents or even to their siblings. Most married clients think, oh, my spouse is going to get everything, but this is just not true for separate property. So this is a real danger zone for anybody who is newly married, doesn't have any community property yet, signed a prenup, really strictly defining their separate property. And this is where estate planning can solve this problem. Number 3, community property waivers create an inheritance vacuum. So the default rule in California is that a surviving spouse inherits 100% of the deceased spouse's community property. But many prenups include a waiver of inheritance rights and a waiver of a community property right and a waiver of a community property claim at death. So here's the key distinction. A waiver prevents the claim, but it does not direct distribution. So if your prenup says, when my spouse dies, I'm not going to try to get any of their community property, then who does get the community property? Well, the children. If there are no children, the parents. If there are no parents, the siblings. If there are no siblings, let's go right back up to the grandparents and go down to aunts and uncles and cousins and so on and so on. Estate planning fixes this problem. Bespoke, customized, carefully crafted estate planning fixes this problem. You can absolutely have a scenario where a surviving spouse receives a portion of the separate property and none of the community property. I have yet to meet a couple that this was their intention on death when they died happily married. Number 4, beneficiary designations override the prenup. Retirement accounts, life insurance policies, RSUs, bank accounts. These beneficiary designations, they bypass an estate plan and they bypass a prenup. If the spouse is named, it passes automatically. If the spouse is not named, they don't get it. The prenup does not override the beneficiary forms. So coordination as to who is supposed to get what in the event of death is critical. Number 5, incapacity is usually ignored when couples are creating a prenup. Prenups don't address who's in charge when it comes to making healthcare decisions. Prenups do not control financial powers. Clients who are engaged, clients who are seeking prenups, they really need to protect each other and themselves by working with an attorney to create these documents, creating a power of attorney, creating an advanced healthcare directive. Without these documents, court involvement might be required if one member of the couple loses capacity. Divorce planning, prenups, that protects in divorce, but estate planning protects in both incapacity and in death. So let's recap. A prenup is not a testamentary document. It does not say who gets what. But a prenup, especially one that includes a waiver, can lead to the unintentional disinheritance of a spouse because of the definition of separate property and because of a community property inheritance waiver. Separate property does not, in any instance, automatically go to the spouse, and community property waivers create a risk if the clients do not create a trust. And for both estate planning attorneys and family law attorneys, we've got to keep an eye on those beneficiary designations because those override everything. A prenup sets up guardrails for divorce, and estate planning writes the roadmap for a couple that's remaining happily married until the very end. But without coordination, California default rules apply. The statutes decide. If you draft prenups, advise clients with prenups, or have one yourself, this is not an add-on issue. Estate planning is structural risk management. My name is Patricia DeFonte. I'm the founder of DeFonte Law, where we practice estate planning with heart. We love working with newlyweds.